Chapter 5. Parties and their capacity. Section 22. Parties and their capacity, in general. In this chapter we shall consider parties to bills, notes and checks and the capacity of such parties. It may be stated that the general rules governing contracts will apply as to the capacity of persons to make and endorse bills, notes and checks, and also as to the effect of the various forms of legal disability, as infancy, insanity, coverture and alien enmity, upon the rights of the parties. Paper executed by persons who are under any of the above disabilities, is either void or voidable. Others, as partnerships, corporations, and agents, who have capacity to make simple contracts also have capacity, to certain extent, to execute and transfer bills, notes and checks. We shall consider in turn the capacity of all these parties to execute negotiable instruments, or bills, notes and checks. For convenience, parties and their capacity may be considered under two main divisions or heads, viz., first, those parties partially or wholly incapacitated, and, second, those parties not incapacitated. Section 23. Parties partially or wholly incapacitated, in general. Parties partially or wholly incapacitated may be classified either as parties lacking mental capacity, such as infants, lunatics, drunkards and spendthrifts, or as persons lacking legal capacity other than mental, such as married women, the bankrupt or insolvent payee and alien enemies. Section 24. Same persons lacking mental capacity, infants. There is a difference of opinion in the decisions of the various states as to whether a negotiable instrument made, accepted or endorsed by an infant, that is, by one under 21 years of age, is absolutely void or is merely voidable. The better opinion is that such note is voidable and may be ratified by the minor after reaching his majority. But before reaching his majority and ratifying the instrument, the infant cannot bind himself absolutely as drawer, endorser, acceptor or maker of a bill of exchange or promissory note if an instrument is given by an infant for necessaries. The better opinion is that the instrument is voidable and if repudiated by the infant, he may be recovered against not on the note but for the value of the articles supplied, or service rendered, actions known technically as quantum vailbat and quantum moot, respectively. An note, bill or check made payable to an infant is enforceable by the infant against the maker or acceptor, as the privilege of avoiding the contract lies with the infant and is for his benefit. The one who pays should use due care in paying lest payment should be made to the guardian rather than to the infant. An infant's endorsement, that is writing his name on the back and making the instrument payable to someone else, is voidable, not absolutely void. He may choose to disaffirm it, and by returning the consideration received, compel the maker or acceptor to pay him, although the money has already been paid to the endorsee or the one to whom the infant endorses it, or the infant may disaffirm the endorsement, notify all the parties, and if payment has not been made to the endorsee, destroy his title to the bill or note. In case of the endorsement of the note or bill by the infant payee, the maker or acceptor is liable, as the fact that they make the instrument payable to an infant stops or precludes them from denying his capacity to endorse the instrument. It would be absurd to allow one who has made an instrument payable to an infant, or his order, to refuse to pay the money to one to whom the infant had ordered it to be paid, in distinct violation of his promise. The Negotiable Instruments Law provides, the endorsement or assignment of the instrument by a corporation or by an infant passes the property therein, notwithstanding that from want of capacity the corporation or infant may incur no liability thereon. As the instrument of an infant is not absolutely void, but voidable only at his election, it follows that, after reaching full age, the then adult may ratify and confirm his bill or note executed while he was an infant. Unless a written ratification is required by statute, a verbal ratification is sufficient. In some states by statute it is required that this ratification be in writing. Section 25. Same underscore persons lacking mental capacity, lunatics and imbeciles. The bill or note of a lunatic, imbecile, idiot, or other persons non compos mentis, from age or personal infirmity, is not binding on such persons during the period of incompetency. There is a conflict of authority in the various jurisdictions as to whether one ignorant of the incompetency of a person with whom he contracts will be protected. The better opinion would seem to be that he will be protected if he has acted in good faith and taken no undue advantage of the afflicted person. That is, he will be protected if the note was obtained or the contract entered into in good faith, in ignorance of the want of capacity of the insane person to contract, and for a full and adequate consideration of money paid, or property delivered to him. As to whether a bill or note given for necessaries binds one under such incompetency, the more just rule would seem to be to place such an instrument upon the same footing as the bill or note of an infant given for necessaries. As discussed in the previous section, contracts with a person who has been adjudged judicially to be insane and for whom a committee or guardian has been appointed to care for his interests are not valid and cannot be enforced if disaffirmed or avoided. If the insanity of a party to a contract is known, the contract is absolutely void. Such persons of unsound mind may be payees of bills or notes and may compel payment to them or a return of the consideration. As payees they may endorse the paper and the endorsee may recover of the maker or acceptor, and the latter are estopped from denying the payee's capacity to endorse if the payee was incompetent when the bill or note was executed. It has been held that the insanity of the endorser may be pleaded by the maker of a note in an action brought against him by the endorsee. But the better doctrine is as above stated that the contract of endorsement by an insane person is voidable and not void, and such contract is binding upon all prior parties to the instrument who are of sound mind. No action will lie on an accommodation endorsement of a promissory note by a lunatic, even in favor of an innocent holder. There is a presumption that every person is of sound mind and capable in that respect of contracting a liability on a bill, note or check until the contrary appears. If a person contracts such a liability with a third person whom he knows to be insane, it is not valid, for unsoundness of mind would be a good defense, if it could be shown that the defendant was not of capacity and the plaintiff knew it. But where a person as above in good faith contracts with another, without notice of any such insanity as affects his capacity to contract, the ordinary presumption of sanity prevails, and the contract is valid, unless undue advantage was taken of the lunatic. Section 26. Same persons lacking mental capacity, drunkards and spendthrifts. If a person became so drunk as to be deprived of understanding and reason and in such a condition signs a bill or note, either as maker, drawer, endorser or acceptor, the instrument as to him is voidable. He may ratify the instrument when he becomes sober and be bound by it. Many courts hold that drunkenness, unless procured by the payee's connivance, must be habitual and amount practically to mental unsoundness in order that it may be set up as a defense on an instrument. The spendthrift, as in cases of infancy, lunacy, or drunkenness, may be placed under the care of a guardian. A person who has been deprived of his property for any of the above causes is considered incompetent to make a negotiable instrument. So likewise a spendthrift when placed under the care of a guardian is held to be incompetent to make a negotiable instrument. By the weight of authority when under the care of a guardian he cannot endorse a note made payable to himself. For if he is held to be incompetent to make a negotiable instrument in the first instance he could not consistently be held to incur any liability by endorsement. Section 27. Same persons lacking legal capacity other than mental. Married women. Wherever the common law prevails, a married woman cannot bind herself as a party in any way to a bill or note, and such instruments signed by her are absolutely void. There were a few exceptions to this, however, at common law, as where the husband was an alien enemy and the like. In those states where the common law has been unchanged by legislative enactment, the common law rules still prevail. If a special or limited power to contract is given them, they are still deemed prima facie unable to contract, and the burden is on the persons relying on the validity of their contracts to bring them within the rules set down in the legislative enactment. Modern statutes in most of the states enlarge the capacity of a married woman as to the making of contracts. The general scope of this remedial legislation is either to give her power to contract the same as if single or contract as if single with reference to or for the benefit of her separate estate, and in either case her power to execute negotiable instruments would be the same as in case of other contracts. In some states she is forbidden to execute such instruments as surety, and her engagements as surety are absolutely void and cannot be ratified by her after coverture is terminated, either by death or divorce. Section 28. Same persons lacking legal capacity other than mental, bankrupt or insolvent payee. A bankrupt cannot endorse a bill or note, since all his bills and notes receivable are collectible only by the assignee or trustee in bankruptcy. Any endorsements which he attempts to make are absolutely void. The one exception to the above rule is that when the bankrupt shall have sold the paper before his bankruptcy, the title obtained by the purchaser will be superior to that of the assignee or trustee although the endorsement was made after the bankruptcy. Section 29. Same persons lacking legal capacity other than mental, alien enemies. In times of peace aliens may contract with each other as other persons may, but in times of war alien enemies cannot contract with each other when it necessitates communication across the line of hostilities. Hence, they cannot execute negotiable paper which is binding either during or after the close of hostilities. Alien enemies are those who are subjects of different sovereignties which are at war with each other. In some cases, war simply suspends the contractual powers of aliens and does not terminate them, but in no case will communications or transfers of property or money across the line of hostilities be permitted. Section 30. Parties not incapacitated. In general, parties not incapacitated may be classified as, first, those acting in a fiduciary capacity, such as executors, administrators, trustees, guardians, committees, and the like. Second, those acting in a representative capacity as agents, partners, private corporations, municipal or public corporations and public officers. Section 31. Same persons acting in fiduciary capacity, executors and administrators. In general, the legal representatives of dissidents, known as executors and administrators, succeed to all the interests and rights of such dissidents. The rights and remedies attaching to all their contracts and instruments, whether negotiable or not, pass to the executors and administrators. The assets of the decedent's estate also pass to these legal representatives, but these rules are subject to the exception that all those rights and obligations arising from the decedent's contracts which are so personal in their character that no one could take his place in the matter, do not pass to his executors or administrators. An executor or administrator cannot make or endorse a promissory note so as to bind the estate of the decedent. By his contract he can only bind himself, and he can in no way bind the estate under his control except as to the debts contracted by the decedent himself. In case he should make a promissory note or accept a bill of exchange and it should be negotiated before due, the executor has created a personal liability. The fact that the executor in making the instrument describes himself as executor does not give him capacity to bind the estate. In case a promissory note or bill of exchange which is made payable to the deceased or his order comes into the hands of the executor or administrator, there is a conflict of authority as to whether either of them may endorse in such a manner as to preclude a personal liability. In case the note has been endorsed by the payee before his death, it is necessary that the note be again endorsed in order to pass title. Section 32. Same persons acting in fiduciary capacity, trustees and guardians. Trustees and guardians have capacity to transfer instruments, but they can incur only a personal liability. An estate is committed to them and they have capacity to hold it and keep it intact, not for themselves but for others. They have such powers as are necessary for them to exercise in carrying into force and effect the estate which they control. If a trustee or guardian executes a bill or note and describes himself as such, he does not bind the estate but incurs only a personal liability. Trustees and guardians, like executors and administrators, cannot bind the estate under their control, or the persons for whom or for whose benefit they act, by their promissory note, or by the acceptance of a bill of exchange. To give any validity to such a note or bill they must be deemed personally bound as makers or acceptors. It has been held that a guardian may endorse a note or bill of exchange payable to his order as guardian so as to pass title, the reasoning being upon the theory that the words as guardian are merely descriptive of the payee. But the better doctrine seems to be that if the endorsee takes such an instrument, the words as guardian should be sufficient to put him on his guard, and if the transfer was in fraud of the trust, the endorsee should be held personally liable. Section 33. Same persons acting in representative capacity agent. All persons who are themselves competent to become parties to a negotiable contract, in their own individual right, can do so through the instrumentality of an agent. It is not necessary that the agent himself should be competent to make a contract, as he is the mere instrument of the contracting party, who, of course, must be capable. The best mode for an agent to sign or endorse a bill or note for his principal, so that it may clearly appear that he is the mere scribe, as it were, who writes for another, is as follows. X, by his attorney or agent, Y, apostrophe or, X, by Y, agent, or Y, for X, or Y, agent for X. It is held competent also for the agent to sign simply the principal's name, and to show his authority to do so by other evidence. If the agent sign a note with his own name, and discloses no principal, he is personally bound. And though he write agent after his name, he is still bound personally unless the name of the principal can be found within the four corners of the instrument. The negotiable instruments law provides, where the instrument contains or a person adds to his signature words indicating that he signs for or on behalf of a principal, or in a representative capacity, he is not liable on the instrument if he was duly authorized, but the mere addition of words describing him as an agent, or as filling a representative character, without disclosing his principal, does not exempt him from personal liability. A signature by procuration operates as notice that the agent has but a limited authority to sign, and the principal is bound only in case the agent in so signing acted within the actual limits of his authority. The power to make or endorse negotiable paper must be expressly granted or given by the principal. Thus the general authority bestowed upon an agent to transact the business of his principal and to receive payment of and to discharge debts, will not imply an authority to accept or endorse bills so as to charge the principal. A power expressly granted is subject to strict interpretation, and must be performed in strict conformity with the terms thereof. Thus it has been decided that a negotiable instrument differing in amount from that authorized, or made payable at a different time will not bind the principal. The implied authority of an agent to bind his principal by a bill or note is upheld in some cases, as where the agent has formally made a note or drawn a bill for his principal, and such principal has recognized his acts. It is provided in the negotiable instrument law that the signature of any party may be made by a duly authorized agent. No particular form of appointment is necessary for the purpose, and the authority of the agent may be established as in other cases of agency. A general authority to an agent is presumed to continue until its revocation is generally known, and if A is the agent of B to draw bills in his name, B will be liable as draw to ignorant endorsees, who had no knowledge of the change in the relationship of the parties, or of the revocation of the agency. It should be noted that officers of the government and other public corporations are not held to the same rule of agency by which in exceeding their authority they bind themselves. Everyone having dealings with a public officer is supposed to know the legal limitations of his agency, so that when a public officer in innocent mistake of the law makes an unauthorized contract in the name of the public corporation, neither he nor the corporation is bound. The officer of a public corporation acting in his official capacity must use care that his official character appears on the face of the instrument, and it is held that merely adding his official designation to his signature will relieve him of personal liability. Below is a form of signature by an agent. Signature by an agent, $100. Minneapolis, Minnesota, July 1, 1909, 30 days after date I promised to pay to the order of Earl Matlock. $100. Donald S. Morris, by Nathan C. Redding, agent. Section 34. Same persons acting in representative capacity. Partners. Partners only have implied power to make and negotiate negotiable instruments in case the firm is a trading partnership, or one whose business necessitates the use of negotiable paper. If it is in the nature and scope of the firm's business to issue such paper, any one or more partners may bind the firm by executing or accepting a note or bill in a transaction within such scope, even though the proceeds are for his own benefit if the holder of the paper was not a party to the fraud. But if money is loaned to a firm on the sole credit of one of its members, and a note is given therefore signed by such member, the obligation is that of the individual member and not that of the firm, and the fact that the proceeds thereof are used for the benefit of the firm is not material. As a general rule, a secret, silent, or dormant partner, whose name does not appear, is bound by notes made or bills drawn, accepted, or endorsed by his CO partners in the name of the firm, both when they are negotiated for the benefit and when given under such circumstances as to bind the firm. After the dissolution of a partnership, no partner has any authority to bind any former partner by giving a promissory note in the name of the firm. The act of dissolution is a revocation of all authority to act for and contract in the name of the partnership. As between the firm and the world, the authority of the ex-partners to bind each other by bills or notes within the scope of the former partnership continues until a sufficient notice of the dissolution is duly given. But notice is not necessary when a secret, silent, or dormant partner retires, for he has not been held out as a member of the firm. If, however, such partner is known to certain individuals to have been a partner, he must notify them of his retirement to escape liability for future acts of the firm. The proper form of signing the firm name to any contract made by a partner is to write the firm name and nothing else. It is permissible but unnecessary to write the name of the partner after the firm signature. Thus, Smith and Brown, per William J. Brown. As to accommodation paper, which term will be explained later, the following rule has been laid down. No one member of a firm can bind it, without the consent of all its members, by signing the co-partnership name as drawer, maker, acceptor, or endorser of negotiable paper for his private accommodation or for the accommodation of a third party, and this for the obvious reason that such a transaction is not within the scope of the CO partnership business, unless expressly or impliedly made so, and that it would ordinarily be without authority and in fraud of the firm. Section 35. Same persons acting in representative capacity. Private corporations. The power of private corporations to become parties to bills of exchange or promissory notes is so extensive with their power to contract debts. Whenever a corporation is authorized to contract a debt, it may draw a bill or give a note in payment of it. Every corporation, therefore, may become a party to bills or notes for some purposes. Thus, a mere religious corporation may need fuel for its rooms, and as an economical measure may buy a cargo of coal, and give its note for it, and such a note would undoubtedly be valid in this country. The cashier of a bank, the president of the corporation or any other administrative officer, as secretary or treasurer, may be expressly authorized to issue negotiable paper for the corporation, or he may have such power from implication by reason of having previously exercised the power. The directors of a corporation are in control of its affairs and have the management of its business, subject to the restrictions and limitations imposed upon them by the articles of incorporation, by laws and statutes. If the issuing of commercial paper is within the power of the corporation itself, such paper may in all cases be executed by the directors acting as a board. So the sole manager of a corporation entrusted by the officers with its entire conduct may bind it by executing a note in its name, especially where the officers had previously acquiesced in his execution of similar notes. The power to receive negotiable paper must necessarily be accompanied by a power to transfer it to a third person, in the ordinary course of its business. Many of the same rules which control endorsement and transfer of negotiable paper by agents are also applicable to officers and agents of a corporation. We have already seen under the section pertaining to agents as parties, $33, the proper form of making the signature of a corporation by an agent or officer. In making such paper, it is generally held that the corporation may dispense with the use of its corporate seal. Below is a form of signature, corporate signature, $250 Street, Paul, Minnesota, July 1, 1909, 60 days after date the Acme Company promises to pay to the order of Joseph Thompson, $250. at First National Bank. Value received. The Acme Company. By James Starr, Treasurer. Section 36. Same. Persons acting in representative capacity, municipal or public corporations. As to municipal or public corporations, such as cities, towns and other like corporations erected by the government as governmental agencies, it is held that there is no doubt that they may have the power conferred on them to execute negotiable paper, but the better opinion is that such power does not exist unless expressed or clearly implied, and the extent of the power may be limited by statute, as well as the existence of the power. Section 37. Same. Persons acting in representative capacity, public officers. A negotiable instrument may be drawn payable to the order of the holder of an office for the time being. This provision of the law was intended to declare the general rule that where an instrument was payable to a person holding a position of a representative character, that he may be regarded as the payee of the instrument in behalf of all the persons whom he represents. When public officers in good faith contract with parties having full knowledge of the extent of their authority, or who have equal means of knowledge with themselves, they do not become individually liable unless the intent to incur a personal responsibility is clearly expressed, although they may through ignorance of the law have exceeded their authority. This should be the rule in case of the making, drawing, accepting, and endorsing of negotiable instruments by public officers, but the cases upon this question are not all in accord with the application of this rule to such instruments.